there to the, as soon as you get on to, right into Townsend, you have that water, they had that water stop there, went there, and then, went to the end.
I didn't see it there either, unless they got, maybe it's been, well, no, they haven't been in front
Well,
of me.
when I got to the second stop, my daughter and son-in-law and grandkid were there, so I was playing around with them until I finally. So we went to that restaurant right there.
This is
Very
the
cheap.
airport.
They got on the breakfast buffet after.
That's when my husband and my friend's husband are. Oh, yeah. While we were running, they dropped us off.
Right.
11 miles down the road to school.
Oh, okay.
So my daughter didn't care. We're only 2 miles away, so they dropped us off at the start line. And my daughter wanted to see her, so they took her to Tennessee. And him and his buddy went and eats breakfast at Sherry's house while they're running.
Yeah, we got on the back end of the buffet.
Still got to stay around. How long ago was that? 6 months? No, we already bonded last time. We held hands. Watch this all again. You scoot it forward. Who's my hands for that? Such a man.
Yeah. There's two, seemed like there's more this year than last year.
So Friday night at the 5K, they said there was 1,400 running the 5K and 20 people running the half. So it was packed.
All right. Division 2 Criminal Court in Knox County, Tennessee is now open pursuant to adjournment. Senior Judge Walton Kurtz presiding.
Okay, good afternoon. This is a continuance of last week's hearing where there was, we had to move it because there was some confusion about the scope of the agreement between council, but I think that matter is entirely resolved, and I believe the lawyers then have an announcement, and I'll let the state's attorney make that announcement, please.
Your Honor, before we begin, the state would like to submit to your honor a memorandum of agreement signed by the parties.
All right? Okay, I have copies of these, so why don't we just go ahead and mark those as exhibits, although I suppose that they're all signed. And, Mr. Thomas will have to make reference to these when he testifies.
Yes, sir. So the memorandum of agreement will be exhibit 1. The withdrawal of petition and waiver of rights will be exhibit 2. Exhibit 3 will be the waiver and agreement. Exhibit 4 will be waiver of trial by jury and request for acceptance of guilty plea will be exhibit 4. And if your honor is willing to accept the agreement, then we do have the judgments that we are prepared to submit. The agreement that the parties have entered into is counts 1 through 18 will be reduced from first-degree murder down to second-degree murder. The recommended sentence for each count will be 25 years to serve at 100%. However, he'll be eligible for any good time credits up to 15% pursuant to 40-35-501. Counts 2, 5, 6, 9, 10, 13, 14, and 17 will merge into count 1. Counts 3, 4, 7, 8, 11, 12, 15, and 16 will merge into count 18. Count 18 will run consecutive to count 1. Again, count 18 is a 25-year sentence to serve at 100%. However, pursuant to 4035-501, the defendant may be eligible for sentence reduction credits up to 15% off of his sentence. So it's an effective sentence of 50 years to serve at 100%. Counts count 20. Count 20 will be amended to show that that 25-year sentence in the especially aggravated robbery, the 25 years will run consecutive to count 1 and to count 19. However, it's concurrent with count 18. Again, it's 25 years at 100%, credit for up to 15% pursuant to 40-35-501, that's up to TDOC. Counts 26, 27, 29, 33, 34, 35, 36, 37, 38, 42, 43, and 44 will be reduced from aggravated rape to aggravated assault, and the recommended sentence is 6 years to serve, and that 6 years will be consecutive to count 1. For the record, count 26 will merge into count 27, count 29 will merge into count 27, count 33 will merge into count 36, count 34 will merge into count 37, count 35 will merge into count 38, count 36 will stand, count 37 will stand, count 38 will stand, count 42 will merge into count 36, count 43 will merge into count 37, and count 44 will merge into count 38.
So the effective aggravated assault will be 27, 36, 37, 38. The non-merging.
Yes, sir.
Okay.
Yes, sir.
Now, in addition, some of the convictions and sentences from 2013 will remain in effect.
Yes, sir.
You want to state those, please?
Yes, sir. And so for the record, what will remain in effect and unchanged will be count 19, that's the especially aggravated robbery. That will remain at 25 years at 100%. Counts 21, 22, 23, and 24. The Class A felony of especially aggravated kidnappings will remain in effect. Again, those sentences are 25 years at 100%. And what will also remain in effect will be the convictions in count 45 and count 46, which merged into the especially aggravated robberies.
Now, is count 18 will run consecutive to count 1?
Yes, sir.
Okay. And then while we've dealt with a host of offenses and pleas and sentences here, I think it all comes back to what was summarized in the plea agreement as a 50-year sentence with in which 85% would have to be served.
Yes, so for the record, let's clarify. It's a 50-year sentence. It's at 100%. As to whether or not he gets 15% off, that's up to TDOC.
Right.
But the judgments will show 25 years at 100%, 25 years at 100% to run consecutive to the other 25 years.
And those credits are based on good behavior?
Yes, sir.
All right. And then, in addition, the parties are moving for me to grant relief under the Post-Conviction Act
Yes, sir.
to make this all Yeah, well, they're the judgment forms?
Yes, sir.
Well, I suppose they need to be handed to the clerk because they need my signature post hearing. Now, with the memo of the agreement to testify, has that been made an exhibit?
The memo of agreement to testify. No, sir, we would like to make that exhibit. That's part of the first one, that's part of the memorandum of agreement.
Memorandum of agreement, yes.
I've got memorandum of agreement, that's exhibit 1. Oh, okay, it's included in the memorandum of agreement. That's paragraph 1.
Well,
But
this
you want the-
memorandum of agreement, appears to be a 4 or 5 page document.
Yes, sir.
Okay, did you say you made that an exhibit?
Yes, sir.
Oh, okay.
I'm sorry, that's exhibit 1, Your Honor. The
Okay.
memorandum of agreement which sets forth
Okay,
the testimony at the trial of Eric Boyd.
all right, is there anything else to add?
Anything else? No, sir.
Mr. Jeffries, do you have any comments?
No, no.
Okay. Well, I'm going to allow this, negotiated agreement to be, to go forward today. I'll be, talking to Mr. Thomas here shortly. The reasons, I'll allow it to go forward, I will, articulate by way of an oral, opinion at the close of this, proceeding, assuming everything, goes as, the parties believe it will. But let me call, Mr. Thomas as a witness, please. Mr. Thomas, if you step up here, please. Raise your right hand, please.
You solemnly swear that testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Mr. Thomas, how much education do you have? Okay. Are you a high school graduate or just make it to the 12th grade? Okay. And have you had any trouble reading and writing?
No, sir.
Have you had any problems, understanding anything your lawyer has, told you about these proceedings?
No, sir.
Okay. Are you on any kind of, medication?
No, sir.
Now, I'm gonna ask you a series of questions, so you understand your answers to me are under oath, and you could be prosecuted for perjury for making a false statement to me. All right, could you hand, Mr. Thomas, then Exhibit 1, which is the memorandum of agreement? Now, Mr. Thomas, this is a written memorandum of agreement, which, as I understand it, reflects the oral agreement you made with the state many, many months ago to testify in the Boyd trial. Is that correct?
Correct.
And did you carefully read this memorandum agreement?
Word for word.
Okay. And is that, in fact, a correct statement of the oral agreement that you entered into back, I think, was it last summer?
Yeah.
Okay, well before you testified in the Boyd trial.
Correct.
And that oral agreement, which is in some detail, required you to testify in the Boyd trial, and then me to set them aside in the post-conviction, to plead to counts 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, and 18. Counts 20, 26, 27, 29, 33, 34, 35, 36, 37, 38, 42, 43, and 44, which is set out in pages 2, 3, and 4 of the memorandum of agreement. Is that correct?
Correct.
And is it also your understanding that you would plead guilty to 2 counts of second-degree murder, receive 25-year sentences to run consecutive for a 50-year sentence, with the possibility that you could earn credits to reduce that by 15%. Is that correct?
Correct.
And you understand that your ability to get that reduced by the 15% is up to your behavior while incarcerated.
Correct.
And then also, in addition to those that we might describe as the main foundation of this agreement, you've agreed to enter guilty pleas and receive sentences in the other counts set out in pages 2, 3, and 4. Is that correct?
Correct.
And is that your signature on this agreement?
Yes.
Well, without going any further, you said you read it carefully.
Yes.
Do you believe that you fully understand it?
Yes.
Is there any questions you want to ask me about that agreement and what you're doing today?
No.
And you did say, and I think I'm repeating this, that this now written agreement dated today reflects the oral understanding that you made with the state many months ago before your testimony in the Boyd trial.
Correct.
Okay. So I believe that I can affirm this as the written, and it's a writing now, but as reflective of the oral agreement entered into by Mr. Thomas and the state many months ago in exchange for his testimony in the Boyd case. Okay, if you'd hand that exhibit back, please. Now, would you hand Mr. Thomas the waiver and agreement, please? Which I think you said was marked as exhibit 2?
Waiver grants and
3, okay. Waiver and agreement is number 3. Did you carefully read this waiver and agreement?
Yes.
Okay. Do you understand that if I grant the state's motion to, under the Post-Conviction Act, to set aside the prior convictions as agreed to, that order by me is conditioned upon you following through on your part of the deal, that you're going to enter guilty pleas to these additional charges. Do you understand that?
Yes.
In other words, I guess to make it plain, after I act to set aside these convictions, you can't say, well, we're going to stop right there and I want a trial. That this is a global settlement agreement that involves both the post-conviction, your remedies under the Post-Conviction Act for me to set aside those prior convictions, as well as your part of the agreement is to plead guilty to these additional charges to give you a 50-year sentence. Is that correct?
Correct.
And if you don't go through with your guilty plea, then I don't go through with finalizing the setting aside of your prior conviction. post-conviction relief. As to the counts 19, 21, 22, 23, 24, 25, and 46. In other words, those counts, referring back to your 2013 conviction, will remain in effect. You understand that?
Yes.
And those sentences that were imposed back in 2013 will remain in force, but they will run concurrent, and they will not increase the total time of your agreement, which is 50 years. You understand that?
Yes.
Any questions?
No.
Okay. Now, Mr. Thomas, I want to make sure if you do have any questions, don't be hesitant about asking me.
No, that's
Okay? Okay, I take it at this point, before I go forward, then, on the waiver of trial by jury, request to accept the plea of guilty related to Mr. Thomas's guilty pleas here, that the state then moves the court to grant the requested relief in the 2013 convictions and judgment forms as set out in the agreement.
Yes, sir.
Okay. Well, then, consistent with this global settlement, I'll grant the state's motion and set aside the convictions and those, on those agreed upon counts.
Thank you.
Mr. Jeffries, before I move into the waiver of trial by jury request for acceptance of plea of guilty, is there anything you want to add here, or any questions you want to ask your client to assure the court that he is well versed in what he's doing?
I believe, Your Honor, that he is well versed, that he understands what's going on, and is ready to go forward.
Okay. And I think you told me earlier, you knew personally that he had read and understood all these documents.
Your Honor, I watched him do it.
Okay. Okay, could we please hand Mr. Thomas the waiver of trial by jury and the request for acceptance of plea of guilty? Okay, Mr. Thomas, that, I take it, doesn't seem to be any question, that's your signature on page 6?
Yes.
Now, this document is 6 pages long, and it's really critical to my accepting your plea of guilty to the charges reflected in the indictment for which you went to trial in 2013. Have you gone over these charges in detail with your attorney?
Yes.
And I'm sure you know that the judge is familiar, because I presided over your 2013 trial. But, so I take it you had no question about the charges against you that were tried in 2013. Okay. Well, let's you and I turn to see page 2. It says, "Please see attached sheet." And these were the charges contained, and these were the charges in that indictment of felony murder, 16 counts, premeditated murder, uh, 2 counts of especially aggravated robbery, 4 counts of especially aggravated kidnapping, multiple counts of aggravated rape, and 2 counts of theft. To the right side, you can see the sentence set out there for all these charges. And are you aware of those charges? And is your, I guess that you and I can both go back to 2013 and recall the week-long trial, the charges against you, and the possible sentences you faced back then, correct?
Correct.
Any questions about this? No. Well, I want to make sure that you do understand these charges, and do you have any questions about the definitions of felony murder?
I believe, I know each and every one of these charges, I know the game behind each and every last one of them.
Okay. Well, let's turn to, on page 5, you'll see, please see attached sheet number 2. And this attached sheet contains the plea agreement. And if you go forward and plead guilty, then you can see that I will impose on the reduced charge of felony murder, the reduced charge being second-degree murder, 25-year sentences in counts 1 through 18. But the critical thing is that count 1 and count 18 will run consecutive, or one after the other, for a total of 50 years. The other convictions will merge into those counts and will not increase your sentence of a total of 50 years. Do you understand that?
Yes.
Also, be aware of the 19, especially aggravated robbery, which would carry a concurrent sentence of 25 years. Count 20, especially aggravated robbery, 25 years consecutive to count 1. Then we have the aggravated assault. Now, I think the original charge in the indictment is aggravated rape. Isn't that correct, General?
Yes, sir.
Through the plea bargaining process, the state has agreed to reduce those to the lesser offense of aggravated assault. And each one of those, 26, 27, 29, 33, 34, 35, 36, 37, 38, and 42, 43, and 44 are 6-year sentences. Some, as indicated, and you said you read it carefully, will merge into others. So really the effective counts, the non-merged, would be 27, 36, 37, 38, and 42. No, excuse me, 42 doesn't, 42 is merged, correct? So it's 27, 36, 37, and 38,
Yes,
correct?
yes, sir.
Any questions? quite like this because normally I just apply the Rule 11 sanctions. You as part of this global agreement, you sort of already agreed to this, and you're really not looking for a trial, I take it, but want to go ahead and enter these pleas and get the benefit of your bargain, correct?
Correct.
But I am required by law to ask you some questions. I think it's already clear to me that you are familiar with these charges and its possible punishment. Is that correct?
Correct.
And although I usually ask this question, the defendant has the right to plead not guilty and have a jury trial, and normally required to ask that. In this case, you're actually asking me not to have a jury trial, which but accept this as part of this global settlement. Is that correct?
Correct.
Okay. If we had a trial, you would have a right to confront and cross-examine witnesses, right to remain silent, and the fact that you don't testify couldn't be used against you, and obviously the right to trial by jury, and you have a lawyer. Do you understand all those rights are potentially available to you?
Yes.
Okay. Now, I take it that your willingness to plead guilty is a result of plea bargaining or plea negotiations between you, your attorney, and the state's attorney, and that resulted in the memorandum of agreement that we previously discussed. Was that plea bargaining process entered into freely and voluntarily?
Yes.
Anybody brought any pressure on you or threatened you in any way to make you enter into this agreement or plead guilty against your will?
No.
Okay. And this is what you want to do?
Yes.
And it's your intention to enter a plea of guilty here. All right. Do any counsel have any? And you have? Did you care? I think you said this before, but you carefully read this waiver of trial by jury and request for acceptance of a plea of guilty before you signed it.
Word for word.
Okay. No questions.
No.
And the attached sheets that contain the scope of the agreement and how it's to be imposed. The counsel for either side have any additional questions they'd like to ask Mr. Thomas to ensure that his plea is knowing, intelligent, and voluntary?
Nothing to say.
Okay, Ms. Fitzgerald, why don't we, I guess if we can categorize these, we have the reduced charge of second-degree murder that runs from counts 1 through 18, with 18 to run consecutive to 1. Do you want to just, for the record, although it's clear in the writings and what you said earlier, but just to be on the safe side, do you want to state that before I ask Mr. Thomas what his plea is?
Yes, Your Honor. So for the record, Mr. Thomas, the agreement's going to be counts 1 through 18 will be reduced to second-degree murder. Counts 1 through 18, the sentences for all 18 counts will be 25 years to serve at 100% in TDOC. The counts are going to merge, except for counts 1 will stand alone, and counts 18 will run consecutive to count 1 for an effective sentence, 50 years to serve at 100%. As a violent offender, of course, he would be eligible for any sentencing reduced credits pursuant to 40-35-501 up to 15%. That will be up to TDOC. Additionally, count 20 is in a special aggravated robbery. He'll be sentenced to serve 25 years consecutive to counts 1 and 19. However,
Okay, let's do this, just so we don't get ahead of ourselves, if you don't mind.
yes, sir.
Let's just take the 1 through 18 as a
Okay.
block, and then maybe we'll have 3 different blocks. So
Okay.
we don't get them all mushed together,
Yes, sir.
if you don't mind. Let me ask you one other question, Mr. Thomas. You, as they indicated your sentence as a violent offender, do you agree that you are a violent offender for purposes of the sentencing law? What, do you want to talk to your lawyer about it?
No, it's honestly, yeah,
Excuse me?
yes.
Okay. You want to,
I don't want to talk to him, no, he's answering, yes to the question.
want me to ask the question again?
You know, I'm saying yes to the question that you answered.
Okay. That you be sentenced as a violent offender.
Correct.
All right. Well, and let me also say, I'm required by law to determine that there's a factual basis for any plea, and I can obviously state as the trial judge in the 2013 trial, and the facts that I heard then, as well as the jury verdict and my approval of that verdict, there's certainly a factual basis for these pleas. In addition, we can incorporate Mr. Thomas's testimony in the Boyd trial, but I especially rely on my own knowledge of this case from the 2013 trial. Okay, Mr. Thomas, in cases in counts 1 through 18, where you're charged with felony murder, what would be your plea to the lesser charge in all 18 of these counts to second-degree murder? Guilty or not guilty?
Guilty.
Okay. Based upon your plea of guilty and the fact, as I know them, I find you guilty, I sentence you in each one of these counts to 25 years. However, these counts 2 through 17 will merge into counts 1 and 18. So essentially, they are the main components of this sentence. Count 18 will, the 25-year sentence in count 18 will run consecutive to the 25-year sentence in count 1, for a total of 50 years at 100% as a violent offender. Okay, General Fitzgerald, if we want to go, why don't you take what we've got up to the aggravated assault, and then we'll do the aggravated assault separately as well, if you don't mind.
Yes, sir. And so next, Your Honor, in count 20, the defendant is charged with a special aggravated robbery. Again, that's a Class A felony. The recommended sentence is 25 years to serve at 100%, and that 25-year sentence will run consecutive to counts 1 and counts 19. However, it is concurrent with count 18.
Okay, and the other counts up to the aggravated assault are remaining convictions from the 2013, correct?
Yes, sir. I'm sorry. Should I
Okay.
state those into the record?
Mr. Thomas, in count 20, where you're charged with especially aggravated robbery, what's your plea? Guilty or not guilty?
Guilty.
Okay, based on your plea of guilty and the facts as I've heard them and know them, I find you guilty. I sentence you to serve 25 years, and those sentences will run as agreed upon or reflected in the judgment form. All right, especially, I think at this point we're 26
Yes, sir.
through 44, please.
Yes, sir. Your Honor, count 26, count 27, count 29, count 33, count 34, count 35, count 36, count 37, count 38, count 42, count 43, and count 44. Mr. Thomas will plead guilty to the lesser included count, the Class C felony of aggravated assault. The recommended sentence is 6 years to serve as a Range 1 standard offender, and that 6 years will be consecutive to count 1.
Okay, Mr. Thomas, and Mrs. Gerald, make sure I get all these counts. In counts 26, 27, 29, 33, 34, 35, 36, 37, 38, 42, 43, and 44. Did I get them all?
Yes, sir.
What would be, where you're charged with aggravated rape, what would be your plea to the lesser offense of an aggravated assault? Guilty or not guilty?
Guilty.
Based upon your pleas of guilty in all these counts and the facts as I know them, I find you guilty. I sentence you to 6 years on each one of these counts. A number of them will merge pursuant to the agreement, and then the additional ones in 27, 36, 37, and 38 will run as agreed upon and set out in the plea form. Now, Ms. Fitzpatrick, Fitzgerald, excuse me, if you don't mind, why don't you state then the remaining convictions that were not set aside in the post-conviction, if you just announce how they will be run pursuant to the agreement, please.
Your Honor, the remaining convictions will be count 19. He will continue to serve a 25-year sentence in TDOC, which is concurrent with count 1. Count 21 is a special aggravated kidnapping. He will remain serving a 25-year sentence, which is concurrent with count 1. For the special aggravated kidnapping, if I didn't say it, 21, and the special aggravated robbery for count 19. Count 22, Class A felony of special aggravated kidnapping, 25-year sentence, which merged into count 21. Count 23, special aggravated kidnapping, it's a 25-year sentence, which is concurrent to count 1. Count 24, special aggravated kidnapping, it's a 25-year sentence that merged into count 23. Also counts 45, which is a theft, Class A misdemeanor, which merged into count 19. And count 46, a Class C felony, which merged into count 20.
Mr. Thomas, do you agree that the imposition of those sentences in that way is consistent with the agreement you entered into?
Correct.
All right. It'll be so ordered, and the judgment forms that I'll sign subsequently will, reflect these sentences. As it relates to the sentences, is there anything else the judge needs to do?
Yes, sir, I apologize. I need to check with the family to see if they want to give victim impact.
All right.
Awesome.
I just wanted to thank Thomas for having the courage to do what he did. And I don't believe you were ever a violent criminal. That's all I have to say.
Solemnly swear the testimony you must give in this case will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes. As Mary said, we're thankful for Mr. Thomas coming forth and doing this, and I hope that at the end of your sentence you become a abiding citizen. And again, thank you for taking time to do this for us. Thank you.
Okay. I think it was apparent by a previous order that I entered that I had some questions about whether the law would allow me to effectuate the agreement that the parties entered into for Mr. Thomas's testimony that's now been ratified in writing by his testimony. And let me address that and explain why at law I've allowed this agreement to go forward. I penned this out in longhand over the weekend. It'll be reduced to a formal memorandum sometime during this week and filed in the case, but of course the court reporter will get it. It's of some import to the court that the Christian and Newsom families have been supportive of the negotiated agreement between the state and Mr. Thomas. Mr. Thomas acted as requested by the state, and his action in giving testimony in the Boyd case put him at some risk and is to his detriment. Mr. Thomas testified in reliance upon the promise of the state, and the state made its offer in good faith. While Mr. Thomas was not forthcoming in his post-arrest statement to the police as to his own role in the murder of Chris Newsom, he did identify Mr. Boyd as a probable person who did the actual killing in his prior statement back in 2013. His information could not be used, however, unless he agreed to testify, which he ultimately did. The state obviously supports resolution of the case pursuant to their agreement in the petition to enforce the agreement. The court holds that it has no authority under the letter of the post-conviction statute to grant the requested relief. There's nothing in the act authorizing relief under the act for a petitioner because he assists the state with favorable testimony in another case. However, a court is not bound by the title of a pleading or by the remedy requested. I consider the joint memorandum filed by the state and the petitioner's counsel to be an agreed amendment and a motion for relief, asserting and seeking to enforce petitioner Mr. Thomas's due process rights. For purposes of this hearing, I must rely on the state's assessment of Mr. Thomas's credibility, as I have made no independent judgment as to his credibility. As stated earlier, the state strongly supports Mr. Thomas's position in enforcement of the agreement. The failure to carry out the agreement to testify under these unique circumstances would violate Mr. Thomas's due process rights under both the Tennessee and federal constitution. He relied on the good faith promise of the state, even though the state had no authority to make the promise under the Post-Conviction Act. The court, therefore, in accordance with the amendment and motion contained in the joint memorandum, and consistent with this court's statutory and inherent powers to remedy constitutional violations, has determined that Mr. Thomas is entitled to specific performance of the negotiated agreement to testify, and the only remedy available which would protect his due process rights is that of enforcement of the negotiated agreement to testify. One final word. It is now clear that the Post-Conviction Act provides no authority to plea bargain testimony, and my decision allowing the plea here should not be viewed as precedent that such a, quote, deal, end quote, is authorized by the Act. The result here is based on the good faith of the prosecutors and the petitioner's counsel in their mistaken belief it was proper. Also, the unique facts in this case and Mr. Thomas's detrimental reliance. Henceforth, it should be clear to the prosecution bar and the defense bar that such use of the Post-Conviction Act is not authorized or proper. There can be no claim of good faith in the future. That's the opinion of the court and the expression of my reason to allow this to go forward today. And unless counsel have anything to add, I'm ready to recess.
No.
All right, court will stand in recess.
Yes, sir. It's what I emailed you. Well, but no, you wanna make copies, can I take this to my office, Christie, and make some copies?
Yeah.
I'll go get some copies right now.